If you're one of the millions of Americans who own the estimated between 10 to 40 million pistol braces currently in common use and circulation in the United States, then you need to watch this video. Because today is not an ordinary day. Today is January 13th, 2023, and the ATF just dropped a 293-page PDF download, link in the description box below, as well as supplementary explanatory materials to clarify whether or not you're about to become a felon. In this video, we're going to be going through what does this mean for you, which pistol braces are affected, what can you do about it, the history of how we got here, when does everything go into effect. My name's Tom Grieve. I'm a former state prosecutor, criminal defense attorney. Let's get into it. Guys, before I get into this, we are a small, humble, growing channel, and I promise this is going to be quick. Please take a moment to show your support, not only for us and our efforts, but also, of course, for the Second Amendment. Click subscribe, like to help us in the YouTube algorithm, share it around social media, all of your different friends, and let me know in the comment field below what you feel about this video, whether or not it's going to withstand a court challenge, and where you see things going from here. Without further ado, here we all go. On January 13th, 2023, the Attorney General signed ATF Final Rule 2021 R08F, factoring criteria for firearms with attached stabilizing braces, which amends the ATF's regulations to clarify when a rifle is designed, made, and intended to be fired from the shoulder. This affects stabilizing braces, or other rearward attachments, as the ATF is classifying them, to determine whether these weapons would be considered a rifle or a short-barreled rifle under the Gun Control Act of 1968, or as well as a rifle or firearm subject to regulation under the National Firearms Act. So that's where we're talking about the NFA, Title II weapons, and so forth. The rule's amended definition of rifle clarifies that the term designed, redesigned, made, or remade and intended to be fired from the shoulder includes a weapon that is equipped with an accessory component or other rearward attachment. In other words, we're talking about pistol stabilizing braces. And importantly, here's what they're focusing on. I'm going to break this down into plain English. That provides surface area that allows the weapon to be fired from the shoulder, provided that other factors, which we're going to get into the definition below, indicate that the weapon is designed and intended to be fired from the shoulder. This rule does not affect stabilizing braces that are objectively designed and intended as stabilizing braces for the use of individuals with disabilities, and not for shouldering the weapon as a rifle. Such stabilizing braces are designed to conform to the arm and not to the buttstock. However, if the firearm with the stabilizing brace is a short-barreled rifle, then it needs to be registered within 120 days from the date of the publication in the Federal Register. This rule is effective the date it is published in the Federal Register, and any weapons with stabilizing braces or similar attachments that constitute rifles under the NFA must be registered no later than 120 days after the date of the publication in the Federal Register, or the short barrel removed and a 16-inch or longer rifle barrel attached to the firearm, or permanently remove and dispose of or alter the stabilizing brace such that it cannot be reattached, or that the firearm is turned into your local ATF office, or, of course, the firearm is destroyed. If that doesn't sound like me talking, that's because it's not talking. That is directly from the ATF website, and that's the summary of the rules that run, again, that light 293 pages, also found within their PDF document. So in essence, in English, what are we talking about? Well, the ATF is targeting braces that basically they believe can be used to be fired from the shoulder and are designed that way as well, and the community, the firearm community, is using it that way. So designed, use, marketed, all that kind of stuff. They're kind of lumping that all together. That's what they're trying to target here. The question is, how do we lay our fingers on this from kind of a statutory, or in our particular case, the ATF rulemaking? In other words, that's what they're going for. They're going for devices that they believe are used, marketed, and designed really, truly in order to be fired from the shoulder. But how do they get their fingers on that? Well, that's where it gets interesting, and we're going to be getting into the specifics of that coming right up. So when does this really go into effect? Because I realize the ATF talked about the Federal Register and all that other kind of stuff. I will update you in the description as I get updates on this, but the bottom line is that this seems to be going into effect 60 days from today. So if you're doing the math, that's March 14th, 2023. Now, the ATF also made some noises in there within the document, and I'm citing specifically from page 15 that, hey, there's some just cause and this and that. They could try to push this up to February 12th, 2023 if they try to claim that they have good cause, but it seems like on page 15 they are conceding the 60-day timeline. So it looks like we're at the March 14th, 2023. Now, by the way, in case you're wondering, the ATF's excuse for changing their mind for the 6th time, and yes, I will get into this and document each occasion later on this video, is that, number one, they did not take into a consideration. In other words, they failed to consider whether the devices could be used to fire from the shoulder when they were accepting them for their approvals. And number two, as well as the fact that some of the braces basically are being used this way by the general community. That's code for the fact that they're blaming it in part on themselves of, hey, we didn't really take this into consideration, but really it's your fault because you're the ones that's using this way. You're forcing us, the ATF, to do this. That's at least my take on it. Again, let me know in the description if you see it another way. Now, importantly, they are not going to the 2021 worksheet 4999 or 4999 or the 4999, depending upon how you heard that. That's the worksheet that had the really hyper convoluted and complex point system, which in this 293-page final rule, even the ATF recognized that, you know what, that was a little bit problematic. So instead, I'm going to read from you right here and put it up on the screen, straight from page 10 of the PDF, what they're looking at and how they're going to get there. Accordingly, the department amends the definition of rifle under 27 CFR 478.11 as well as 479.11 to expressly state that the term designed or redesigned, made or remade, and intended to be fired from the shoulder includes a weapon that is equipped with an accessory component or other rearward attachment, in other words, a stabilizing brace, that provides surface area that allows the weapon to be fired from the shoulder, provided that other factors, as listed in the amended regulations and described in this preamble, indicate that the weapon is designed, made, and intended to be fired from the shoulder. The other factors are, and there's going to be 6, number 1, whether the weapon has a weight or length consistent with the weight or length of a similarly designed rifle. Number 2, whether the weapon has a length of pull measured from the center of the trigger to the center of the shoulder stock, or whether the rearward accessory, component, or attachment, including an adjustable or telescoping attachment with the ability to lock into various positions along the buffer tube, receiver, extension, or other attachment method that is consistent with similarly designed rifles. Number 3, whether the weapon is equipped with sights or a scope with eye relief that require the weapon to be fired from the shoulder in order to be used as designed. Number 4, whether the surface area that allows the weapon to be fired from the shoulder is created by a buffer tube, receiver extension, or any other accessory, component, or other rearward attachment that is necessary for the cycle of operations. Number 5, the manufacturer's direct and indirect marketing and promotional materials indicating the intended use of the weapon. And number 6, information demonstrating the likely use of the weapon in the general community. End quote. Right, so that is kind of a mess that will likely require the ATF to call ball or strike on a case-by-case or a brace-by-brace basis, which is exactly what they've begun doing, by the way. Some of the links in the description below are where the ATF has specifically made some preliminary rulings saying, look, this is going to be a rifle/SBR, this one won't. So be sure to check that out in the description after you go through the video. But for right now, you can see that they are not necessarily making super specific, at least in the rule itself, as we've seen with some assault weapon bans out there. See our videos on those. But they're not making super specific rulings of this particular brace is always going to be that way or anything like that. Not in the rule itself, again, being the very operative phrase. You got to scroll down, check out the supplementary materials that they're providing on what's balls and strikes. But you can see kind of what they're looking for. They're trying to figure out basically, how is the item going to be designed? What is this going to be designed for? And basically, is this really much more consistent with a rifle design or with a pistol design? And that's kind of how they're fumbling around for it, and that's how they're going to be building those arguments. So guys, this is going to be really important. We are far from done yet. There's some really important information coming up that we're going to get into right now. An important reminder to all of you new excited SBR owners out there who have pistol braces that are now being classified or reclassified by the ATF into the land of rifles. I want to remind you of the fact that you cannot take an SBR across state lines without first filling out a form 5320.20, which is also linked in the description box below. Failure to do so can be bad news, and that must be done in advance. You've got to get permission from the ATF. So this is not necessarily a normal rifle or anything like that if you're new to the NFA world. Also, speaking of new, for all of you new SBR owners out there, your new rifles are going to be subject to 922R compliance laws. What are we talking about? 922 compliance laws basically deals with importation restrictions and all that other kind of stuff. As a note, handguns were exempt and are exempt from 922R, which is the reason why your pistol with the brace had nothing to do with any of this. But once again, I'm going to skip the Latin lesson here and just kind of flag for the fact that 18 U.S.C. 922R may require that you have to swap out a certain number of parts from your imported SBR or rifle for American-made parts. So yes, if you have an American-made pistol, then you're basically not going to have to worry about this because we're talking about American-made parts. However, if you have an imported brand of pistol that was made foreign, then according to 922R, you need to make sure that you have enough qualifying parts in this to make sure that you're going to be okay. Guys, if you want me to set up a video about 922R compliance, let me know in the comment section below. I really want to keep this focused on the new pistol brace law, so I'm going to just pause that and move on. I think it's also going to be really relevant to get into how did we get here? Because this could be really, really, really important, not only for you as a conversation piece when you're talking with folks about this particular ATF rule, but also when it comes to a legal analysis of where this could wind up going in court and what are some of those arguments going to be. And by the way, we also released a fantastic video earlier today on January 13th talking about what might be some very strong potential challenges based on a federal Fifth Circuit Court of Appeals decision called Cargill v. Garland. So check that out, link also in the description box below. So many description box links. Can't believe it. Happy Friday. So how did we get here? Let's briefly pause and recap this because this is, again, going to be very relevant. In 2012, an FFL submitted the first stabilizing brace sample to the ATF to review as a prototype. They explained that it was designed to help folks with disabilities fire heavy pistols, such as AR-15 pistols, more accurately. The ATF concluded after a review and analysis that the submitted brace did not convert the weapon to be fired from the shoulder such that it would alter the classification from that of a pistol to a rifle or SBR. The company was SB Tactical, and they partnered with Sig Sauer and Century Arms that hit the market with their products somewhere in May of about 2012, as I recall. They were almost an instant hit, and just as instantly, people began shouldering them to fire. In 2014, the ATF announced that despite folks using braces for shoulder fire, that it did not change the pistols into any other type of SBRs or rifles. Okay, so in 2014, they're backing up the 2012 analysis, taking into account how people are using them. All right, fair enough. Then in 2015, the ATF suddenly dictated that basically how you use the brace now matters. If you're going to be Velcroing it around your arm, which is basically how most of these, if not all of them just about, are designed to be used, then you're okay. Your use is fine and you're not altering it into anything other than a pistol. So in other words, good to go. However, if you're using it for shoulder fire, felony, because you're now in possession of an unregistered NFA item, namely an SBR. So basically, the use of the device, the use of the property, somehow changes the essence of the property. This sounds more like philosophy or theology if you ask me, but again, this is 2015. So what happened? Well, so basically SB Tactical and Sig Sauer sued to basically reach some clarity. Then in 2017, while things were still kind of chugging along, the ATF changed their mind again and said that, you know what? We guess that it doesn't really matter how the user uses the device because after all, changing it doesn't necessarily change the device. It does not alter the essence, in other words. So in 2017, the ATF backed off, therefore changing their mind again. Then in 2020, a different manufacturer released an AR-style pistol with an SB Tactical brace that they named the Honey Badger. YouTube classic. ATF sent them a cease and desist letter claiming that it was indeed an SBR. The company named Q, like the letter, sent a $200 refund to each of the people who bought a honey badger, presumably to give them $200 tax stamp money for them to comply with the ATF's decision, as well as, of course, verify it to stay out of trouble, and then started to take legal steps to sort out what's the legal status of their platform. Later in 2020, the Department of Justice, the DOJ, under pressure from the usual suspects across the political spectrum, released a 16-page proposal on braces that allowed for public comment. And this is interesting. In only 17 days following the release of that proposal and being eligible for comment, there were over approximately 60,000 comments, and almost all of them were against the proposal. As further proof that your voice can change things and that you should participate in the political process. And by the way, I'm staring through the lens directly at you, Dale Gribbles out there. The DOJ backed down and withdrew their proposal. Right. The less we talk about worksheet, of course, 4999 in 2021, and again, that hyper-convoluted point system that would leave your tax accountants scrambling for spare batteries for their calculator, the better. That gets us to today, January 13th, 2023, where we have our new light, fun, easy reading 293-page final rule. And again, I will remind you and plug for the video that's in the description box below, that may not matter if it's dead on arrival thanks to the legal reasoning contained in Cargill v. Garland, which is that Fifth Circuit Court of Appeals decision which took on the bump stock challenge with the ATF. And in my view, a lot of that directly pertains to exactly what we have here. Also for FRT forced reset triggers. But again, maybe that sounds like another video that could be coming next week. We'll see. Also, on that note, again, another shameless to consider, please showing your support for our channel as well as for the Second Amendment. Click subscribe, help us out, so that way you also don't miss any new content that's coming out. So if you're keeping score at home, we now have the ATF and the DOJ, so collectively the federal government, changing their mind 5 times. We had the initial rule that came out saying it's legal. Fine, 2012. Then in 2015, they changed their mind to say that it was illegal dependent upon use. All right, now changed our mind once. Then they changed their mind back. Okay, that's 2 times. Then in 2020, we have the DOJ proposing the rule. Okay, that's now 3 times. Then they backed off of it 4 times. And now here we are at 5 times. The government has changed their mind on this. And this is for what the Congressional Research Service, again, estimates is for between 10 to 40 million devices owned by millions of Americans nationwide. That conservatively, again, really puts this number super high up there. We're not even talking dollars. That's people, 10 to 40 million devices and millions of owners. It sure is a good thing that, of course, we aren't talking about, major felonies that can put people in prison for potentially decades, depending upon the number of devices that they own. It is also nice that they released a very simple, easy to read 293-page document with supplementary explanatory materials as well. So that way, when you're making dinner for your family or taking care of the kids, you can kind of breeze through that on your cell phone and not go to prison. And of course, anytime that you change your mind 5 times and then you have to clarify it with a 293-page rule with supplemental materials, let's be honest, there's nothing clear about that. This is an ambiguous as mud rule. And not only that, but the ATF is further opting people into a mess of NFA laws, interstate travel restrictions, and 922R compliance issues. Again, don't forget about that. Don't dodge the big problem only to find yourself up in all these small ones. And keep in mind, if you don't want to SBR your pistol, and if you want to opt out of the NFA and the 922R mess, then that's okay. The ATF has solutions for you, and boy, just wait for them. We, of course, already covered a few of them before, but also helpfully, from page 13 of their document, you can also basically remove and destroy the braces, destroy the firearm, as well as surrender the firearm to local law enforcement, including the ATF. There's your solutions for you. They do throw you a bit of a bone in saying that you do not have to pay the $200 if you do want to go ahead and tax stamp this, assuming you have a qualifying device and you're acting within the qualifying time periods. So probably that 60 to maybe 120 days. Let me know in the comment section below. Right now, as we're filming this on literally, about 4 o'clock or so on January 13th, we don't have all that clarifying information. So guys, if we get a final issue on that, post it up in the comment section. I'll add it to the description, and maybe I'll look at painting it too if I can technologically sort that stuff out. But just as a reminder again, also, by the way, if you want to have a quick link on guidance on how to do that, that link is also in the ATF link in the description box below, as well as, again, that 5320 compliance issue for interstate travel, if you're looking on basically what does that all mean. And in case you were wondering, by the way, and this is rich, so if you stayed around this long, this is your little like Easter egg cookie, okay? On page 186, the ATF acknowledges that, you know, people may consider this to be a slap in the face. That's what them reading from some of the comments about the fact that millions of owners have these pistol braces after the ATF has blessed them and said that they're okay. About, of course, the insanity about them changing their mind 6 times, the ambiguity that their final rule brings, and let's just face it, the overall situation. And we haven't even touched on the constitutional concerns, which of course are first and foremost. But they want to assure you from page 186 that they took all of this, and I'm sure a lot more, into consideration, and they feel confident that they've handled the situation well, and that they'll prevail in court while respecting the Second Amendment. Guys, they throw some of their legal arguments in there. If you want to check it out in the description box below. If you want me to pull it apart and really sink my fingers into this, let me know as well in the comment field. Post that up. Let me know if you want me to take a look at that. But for right now, guys, we really appreciate you staying around this long. I love you. The algorithm loves you. Again, let me know in the comment section what you think about this. Is this going to be challenged? Is it going to be dead on arrival? Check out our other video that we talked about as far as the pistol brace ATF bans and the ATF pistol brace rules going to be dead on arrival. Again, linked in the description box below. If you've made it this far, please consider subscribing. You'll not only, of course, support this channel and the Second Amendment, but also, of course, you'll be supporting and making sure that you get to see all of our videos as we come out. Please also consider clicking like to help us with the YouTube algorithm and sharing on social media. Guys, we'll see you in the next one.